Welcome to Talkin Divorce. Real conversation, real guidance. With Donald Schweitzer and Lori McShane.
Today, we're exploring the legal pieces families often miss when a marriage begins to change. And joining us today are Phil Barbaro Jr., a certified specialist in estate planning, trust, and probate law, and Ali Smyser, an estate planning specialist with Schweitzer Law Partners. So Don, I'm excited for our show today because I want you to explain to our viewers how from a legal side needs to blend in with a probate attorney and estate planning while going through the divorce process.
Yeah, Lori, one of the things I do during my consultations, it's probably maybe the fifth question that I ask of a person that I've just met, is do you have estate planning? Do you have a will or a trust? Have you ever met with a probate attorney? 99% of the time the answer is no. Some of them do, and they need to have their things reviewed before we start. But it's a foreign land, but it shouldn't be because there's so many crossovers between family law and probate. They're very important to a family law litigant, and of course it's very important to the people that are in probate. So I'm fortunate because I have a partner, Ali, here, who is a certified estate planning attorney, and she takes care of that for our firm. And then my really good friend, Phil Barbaro, who's been practicing forever, in the same area. So he's a longtime probate attorney. He's a litigation person, experienced, well-known, and he's also now a mediator. So he works for a company called ARC. It's the firm that he works with. And he's going to talk today about how people get into mediation in these matters and, what people should know, because this is, like I said, is an area that most people don't know. Isn't that true, Phil?
That's very true, yes. When you're dealing with divorce or in the probate trust situation, these families are at probably their lowest point in terms of conflict, and it is such an emotional place. And that mediation gives you the opportunity to avoid the stress and strain and financial drain of litigation. So it gives a good informal place for them to try to resolve these disputes while hopefully maintaining the family ties that litigation will tend to tear apart.
Yeah, and so Ali, I always talk to you about how crazy my cases are. My clients are, very emotional. That never happens with you guys, right?
Never, ever. No, I mean, in both cases, there's so much emotional stuff happening, right? It's a lifetime of, with the families at least, with siblings, right, Phil? It's just a lifetime of growing up together, how mom treated me, how dad treated me, how the family dynamic was. And Phil and I have worked together on mediations, and it really gives families an opportunity. I mean, we're not sorting out all their emotional baggage, but it does give them a time to share with the mediator where they're coming from, what those underlying emotional aspects are. And I feel like they're really heard. I feel like that it really accomplishes a lot for the case and for the family.
And that's really what the role is, and that's where I spend my time talking to them to make them understand, number one, that I understand from litigating for 30 plus years. I know what clients are going through, but also letting them know that it's not just about the dollars and cents. It's about what happened 20 years ago. It's what happened, what did a parent tell you? And in many cases, they're both doing what the parents told them. It's just that the parent told them two different things. And so it's making them understand that we're here to resolve it. The other thing that's important for them to know is that when I do the mediation, I tell them this is the most you're going to ever get out of this estate is what we do today, because once we get beyond this, if it doesn't settle, you're now going down the road of litigation, and we all know litigation.
Well, let's talk about that, because in family court, the judges say, hey, you better try to go to mediation because neither one of you are probably going to like what happens at the end of the trial, and you're going to spend all kinds of money. You might actually spend so much money that there will be nothing left. And I assume that it applies to your area of law like it does most areas of law, that mediation serves a really significant, good, valid purpose.
Definitely, because in an estate, you have a pie that is only so big, it does not get bigger. This is the final, and many times I call it the final battle between the family in a sense. And so the more they spend, the smaller that pie gets. And I try to get them to understand that by resolving this today, as maybe as difficult it might be, it's going to maximize what they're going to get out of this estate.
Yeah. So, Phil was talking about the emotional aspect of it, and I kind of key into this by watching you with your cases, that it's not necessarily about the money. And I feel the same things about divorce. A lot of times it's not about, the pots and pans or even the 401k. It's more about there's this emotional tug between the people. But it seems like it's even more pronounced because you've got families that have been together forever. And like you said, they're talking about who loved me and, grandma didn't love you and, she gave you this. And how do you deal with that as a practitioner?
It's so hard. But, you just sort of have to understand where the people are coming from and then redirect to the things that they can control, right? So one of my very first cases, there were two siblings against two siblings. And I thought, we're going to be talking about the money and the bank account and the houses. I mean, we were fighting over Christmas ornaments, Dad's old lazy boy chair that you would pay someone to take away, and so that in that moment, I mean, it was a light bulb that was like, this has nothing to do with, with that dollar amount that's in the house, but it's just allowing these two, in that case, it was just two sets of siblings, kind of sort out how they came to that place. I don't think they're best friends today, but I think it was very helpful for them to be able to at least go down that road together.
And that's the benefit of mediation, and which is also one of my opening statements I tell them, is that it's the one day where you can tell your entire story. Because I tell them about half of what you tell me today is not going to be admissible in court. So the judge is never going to hear it. But I can hear it. You can tell me everything. We're not restrained by the rules of evidence. So as Ali was saying, you have all of these other issues. Well, the court's not going to be hearing about Christmas ornaments in a trial. But in a mediation, you can hear all that stuff and you can help them. It helps us get to the root of what this conflict is about. It's about money, but in the bigger picture, they want to know that they're valued and they're equal.
So let's talk you through, or you talk us through the process, okay? Because your world could have a lot more people than mine does. I've got a husband and a wife, usually, okay? Or a father and a mother. You've got lots of people that have a stake or think they have a stake within an estate. So how do you handle the volume of people that could potentially be?
It's very, I think the mediation I did with Ali, I think we had 9 people in one room and we had 3 or 4 in the other room.
So you separate people?
Oh yeah. So
in camps? It sounds like in camps in this case.
Yeah, we do. So everybody is in a different room unless they want to be together, but typically they're separate. So basically it's going from room to room to room, just basically kind of getting everybody's story and then getting them to the point of talking, finding out. I spend the first part just kind of finding out, what are we here for? What is the real, I know what the dollar, I know what that is, but why are we here? Why are we fighting? And so sometimes, I'll have a number of different people to do it. And you just try to pick it up. So, and then you're hearing. And so it takes a while, because when you have 9 people, there's 9 stories.
Do you normally get it done within one day?
I was just thinking about that, the turnaround.
So most of the time you can do it in a day. A lot of times it takes a couple of sessions. And it's always interesting because they always think it could be done, because it's like everyone will come in with an opinion of what they're going to do. We're not doing anything more. And I always tell them that when they come in. I said, I know everybody's locked in, because I had clients and they had the same thing. And I tell them, that's fine. I'm not going to ask you to change what you think you want. All I ask is that you remain open for this process and let the process play out. And if we do that, 80-90% of the time we'll settle the case. And I get them to promise me they'll just stay open. Not that what they're going to do, but just that they'll stay open. So what happens is you spend hours going through stuff, and we start getting towards the end, we start getting really close. And
that's when the first starts flying.
And next thing you know, you're at 6 hours, 7 hours, and we've gone 14 hours, and we've got it wrapped up. So we typically sometimes we'll do a second session.
Okay, I thought you were headed where I always see. I see right at the end that we've got everything settled, but there's one very small thing, and I was saying it blows up. People start getting angry, and because they just got to get that day in court if they can, or whatever it is.
I just wanted to ask a question related to that, and I think this is in the family law context too. So for both of you, it does require, though, for the parties coming in to have an openness to the process, right? So if you've got parties that are just, it's my way, that's not very productive, right? So is that true? How do you counsel your clients in that way to be sort of open to the process?
Not easy sometimes. So you were with Phil, and both of you are really experienced attorneys in your field of practice. There's a lot of different subjects that could come up in your world. It's not just an estate or a division of property, right? I mean, you could have conservatorships, you could have guardianships, you could have a lot of. Could you describe some of the things that you mediate?
Sure. Yeah, so many times it'll be a trust matter that's being litigated, but prior to that there was a conservatorship, and the conservatorship wasn't completed before that happened. And then because not everything was in the trust, there'll be a probate on top of that. So there'll be a probate, trust, and conservatorship issue that you're dealing with in terms of that particular mediation. There's issues regarding marriages in some cases.
Well, why don't we talk about that?
That's why we're here, isn't it? That's the whole
I
point.
guess so. I guess that's part of the
point.
reason we're here.
But yeah, you can. If someone passes away while the divorce is pending, the divorce aspect may go, but you might have some other issues you got to resolve. And then you'll end up dealing with those in the probate court. They have jurisdiction. So I literally tried a divorce in a probate case for the most part.
Oh, you did?
Yep. Yeah.
So Ali, talk to us about some of the crossover cases that you've had, without naming names, of course, but some of the issues.
I mean, we have had definitely the conservatorship area that overlaps. Also with if a parent dies who's paying child support, you can, the surviving parent can pursue the estate for child support, right? We've had those kind of issues in our office.
Well, the other one that I'm thinking of is if somebody owes a bunch of child support and they're like, hundreds of thousands of dollars in debt to the other side, and we know that person is going to inherit.
Yes. So there's a provision of the probate code that allows the person who's owed the child support to pursue the beneficiary's interest in a trust. Yes. Okay. That's not very common. Have you seen any cases like that?
Not support,
Oh,
but
okay.
there are situations where you'll have property issues, or there'll be litigation that's pending unrelated to the probate, but you got to deal with it in those contexts. So,
I always wondered about community property. We have our definition of community property. I assume it's the same as for your world, but it seems like it's litigated in probate court, even though it's been kind of decided in family court. Or what goes on when there's a dispute with regard to that?
well, it depends on the situation, and what that would come up would be when you have an omitted spouse situation, where So if someone has a trust, and anytime I have a client who is, I had it happen one time where I'm just doing an amendment to a trust. His wife had passed years ago, and we're just doing this amendment, and he said, "Oh, by the way, I'm going to marry so and so in a little while." I thought, "Oh, wait, stop." And I wanted to make sure that we did an amendment to indicate that I'm going to marry her, I'm not providing for her, and all that, because if you have an estate plan in place and you get married after and you don't say anything about the spouse and you don't do anything and you then pass away, that spouse now is a beneficiary of that estate. Half of the community property and all of the and a portion of the separate property depending on having kids. And you talk about a hard conversation.
Yeah.
Tell the kids that, oh, by the way, your stepmother, who's only been married for a year, and your father did his trust 10 years ago, she gets half of the community property and a third or a half of the separate property. That is not a comfortable conversation.
No.
But it does.
Yeah.
Does happen. So anyway, in answer to your question, that issue of community property becomes really pronounced in that situation because she gets half of the community. So knowing what this community is very important in that context.
Okay, so you are dealing with people that have a lot of different emotional issues, but I'm sure you see certain patterns that of behavior that interrupt the proceedings, or it doesn't get where there's not a quick resolution and they have to come to you. What are some of the things people are doing out there that, if you could advise them ahead of time, if they're going through the probate, or what are some of the tips that you would have?
As far as the person doing the estate plan, or as far as?
No, it's a litigant. They're walking, because in my world at least, we wouldn't need me, the divorce attorney, if people actually didn't have emotions. Right? Just it goes here, it goes there. And so I have a feeling that it's pretty true just about all areas of law, especially yours. So are there things that people are doing out there that are like, yeah, that was probably,
I see it, and many, I'm sure Ali as well, where a parent will think, well, I got 2 kids or 3 kids, they're going to do the right thing. I'm going to put title in the name of, one person, and he's going to divide it. When I die, he's going to give it to everybody. Or I'll put him on the account, and he's going to give it to everybody. It does not happen.
It doesn't play out that way.
Once the last parent is gone, sometimes these siblings are strangers to each other. It works in some cases. When you have a real functional family, it works, and you can do it blindly. And I know plenty of families they could do that. But you're talking about the problems when they're is where a parent thinks, they don't do an estate plan. And they'll say, well, put so-and-so on title with us, and then he's going to distribute, or she's going to distribute to everybody the way we asked him to. And guess what? It doesn't always work out.
So people relying on oral agreements or statements that were made.
Exactly. Okay. Yeah. So they have to do that, and then the typical one is, there'll be an estate plan that's in place for 5 years, 10 years, 20 years, and in the last year or less, a sibling who hasn't been around much, suddenly is now there, and there's a change.
It's a big change.
Now they're the trustee, and now there's this, and that might be legit, might not, but so you want to be sure, as an estate planner, you want to make sure that is well documented, and you have all the things you need to know that they have capacity, they're not unduly influenced, that type of thing.
So Ali, what did you think? Did he settle your case for you?
He did. He did. And I actually didn't think we were going to get there, honestly. I felt like it was like we started out good, and then it sort of, the bottom fell out, but we got there in the end, yeah. And we sort of had to settle. There wasn't liquidity in that estate, so we had to settle. So he did a really good job, and I think that people.
And they hugged me when I left.
Yeah.
They were happy. They were very happy to have it over with.
Sometimes that hug is more important than anything else. I was saying that recently. I left court, and my client gave me a hug, and I thought, I don't get those very often. And it's like it made it all worthwhile. And stuff.
Right, yeah.
So you're in situations where, again, you've got multiple people in different rooms, and I guess I'm obsessed with that idea.
Sure.
Because we only have me and my client and maybe an associate attorney with me, but you've got all these family members, and sometimes they team up, and there's like a fight on type of a thing. How do you deal with that many people when you're going into the room?
Well, when if they're all in the room, in Allie's case, I probably had 7 or something in her room, and it's basically kind of hearing them all out. What are everybody's issues, and then trying to put it all in perspective and say, okay, we could do all this fighting, we could do all this stuff, but what's the bottom line here? Are we going to do you want to walk out with something? Do you want to walk out, and how important is that fact? I mean, it's very important to you emotionally and everything else, but in terms of what we're doing, when I leave and we don't settle, what's going to happen? You're going to have a deposition. Your life goes on. And what I tell them is, like, especially when we're close, I said, once you sign today and you walk out of here, it's over. You don't have anything more to worry about. You don't have to pay your attorney anymore. You don't have to do all these things. It's over. It's done. And for some reason, that really resonates with them at some point.
Shoulders go down. It's like,
exactly. Yeah, because they know, and I said, when you walk out of here today, you're done. It's over. And that's the thing that really they look for. But you have cases where it's not going to happen.
Sure. There's some cases that won't settle.
Right.
But when you're going into these rooms, the one thing that I could think of is that you might be doing is looking at who's the one that is more rational, or is listening to you and is not so hyped up, because they tend to maybe give good counsel, when you're not there or something, or help make the decision.
Yeah, I would say, and I'm sure Ali would agree, a lot depends on the quality of the lawyer that is representing them. So if they have a lawyer that really knows how to evaluate, talk to them, manage expectations, and here it makes a huge difference in helping the mediator get the case resolved. And in some cases, frankly, they're looking to the mediators like, I've been telling them this for like 6 months. They want to hear it from you. And so then they're
It's
like,
true.
yeah. And they're like, see, I told you, this is what it, and so sometimes that's what it takes. It takes for someone else to tell them exactly what they've been hearing from their lawyer. And it tends to work. And that's why mediation really has a great impact, and it's such a service to the community that's unfortunately in litigation.
There is definitely a divide between representing somebody and telling them flat out, this is how it's going to go, you ought to be thinking about this, and when they get into mediation and they hear it from the authority, suddenly they're more receptive to that. I've noticed that through the years when I mediate. So people put a lot of stock in what you say because of your years of experience and that you're completely neutral.
Yes, definitely neutral. I mean, I don't have, from my perspective, my goal is, and I tell them that, I said, I'm not here. If you go to court, the judge is limited. He can only say you're right or you're wrong, and then you get whatever remedies he can get. I said, here we could be very creative. I said, we could carve out a settlement or a solution that fits all the weird things you're talking about. You can get the Christmas ornament, and you can get, and those might be the things that make a difference. I mean, I had one where he wanted his father's FBI badge, and it's like I didn't even know that was
That's important. Come on.
But I didn't even know that was an issue because it doesn't show up in any of the pleadings. But all of a sudden, it was like, oh, they had some of these personal things they really. So you can do things in mediation you can't do if you. And so when I explained the fact that we're going to get away with things here that you can never do in court. So if we don't, or if we have a stalemate, tell them, okay, if we go to court, this is what the court's options are. Today we can do something different.
Creativity has play in mediation as well. I notice that when I resolve cases in mediation, I'm depending on the mediator's ability to think out of the box. And that's where, again, the years of experience that the two of you have to be able to come up with solutions that aren't readily apparent to a layperson or somebody that doesn't have a lot of experience. And wouldn't you agree that, every year that you put in as a litigator really helps you, looking at the big picture?
Oh, definitely, most definitely, yeah. That's really what mediation is basically finding whatever it takes for these folks to finally realize that's going to be the best solution for them. So yeah, it's a process, literally.
Yeah. Now you're also a past president of the Pasadena Bar Association.
Yeah.
Long Lori, I'm going to tell you that you're talking about 3 people that are very loyal to the Bar Association. So I've got to say this, is that Phil and his company have been a part of our association for many years, ARC, and they really provide some awesome mediators and stuff. And I've known Phil through the Bar Association, past president. In fact, when I joined, he was the president, and now he's with these esteemed people, doing this great work. So how much of your life now is devoted to mediating versus being the old litigator?
Yeah, so I wound down I wound down my litigation a little bit. I'll still do some because I still represent professional fiduciaries, so if a case requires litigation, I'll still do it. But I'm doing probably 50% of my practice is
wow.
Of mediation. Yeah.
That's congratulations. That's really good.
Yeah,
and really, they don't. That's the mediators are really the top of their field. So the fact that Phil was invited to join this group and has been now very successful at it like that, it really says a lot about Phil and his practice. Well known throughout the area. I think if you talk to anybody in town, right, they know Phil Barbaro.
Yes.
And it's true. They do. And he's been around. He's helped a lot of people.
Wow.
Yeah. And so, and do you operate solely at the ARC headquarters, or do you do things Zoom?
Yeah, we do most of them are Zoom.
Okay.
And I do belong to another mediation group as well, so I do a lot of mediations from them. But but ARC has state-of-the-art facilities on Westwood, downtown LA, brand new, and we also do Zoom, and they provide great support. So a lot of these are Zoom, which makes it very good and convenient for litigants because sometimes it's hard for them to get downtown.
Well, I was thinking coming in here that some of your people are in different countries, different states. When you got these families, they're dispersed all over the place.
Yeah.
You can't get them into one room, right?
No, I did one. We went for hours and hours, and his attorney made a comment, said, well, he's probably ready for bed. It's like 4 in the morning. I said, where is he? I think it was like in Honduras or someplace all day. He was in, Aruba. I don't forget where he was. I think Aruba. And it's like, I had no idea. It was just like we were just having a conversation. You know, well, we were.
Do you notice a difference in the results if it's Zoom or in person?
You know, initially I thought there might be, but no, people hang in there. They stay. And like I said, we've had some that, we thought we would do 6 hours, and we ended up doing 12 hours, and we went to 2 in the morning, 12:30 in the morning, and everybody hung in there. Documents were signed. No one wanted to get off until everything was signed, emailed around. So it's ironically, it works.
Amazing.
Do you have a preference?
I mean, it just seems like in person is just more
Emotional.
Yeah,
it's like more physically there.
Yes,
Okay.
yes.
Now I'm going to take the opposite side, and that is that I like to sit in my office with my client and have that comfort level and just relax and stuff. So I guess it's different, things for different people. Listen, we got to end it here, but I do want to say this. Thank you very much for joining us, and you got to come back here. We got so much more to talk about, on this show.
Well,
thank you very much.
Thank you for having me. Thank you, Laura.
Of course.
Great. Thank you so much.
Buying a home before divorce is final. So here's the scenario. Someone filed for divorce, but the final judgment hasn't been issued yet, meaning that they are still technically married. They want to purchase their own home during this time. So Don, the question is, if somebody buys property before the divorce is finalized, are there legal or financial complications they should be aware of?
Not only complications, Lori, but considerations should be taken. One of the things that runs in these situations is whether or not the money that was used to pay for the new property was community property or separate property. So the person that's purchasing the property could be walking into a trap, because you don't want to get out of your divorce without prolonged litigation, right? You want this divorce to end. Well, guess what? You might be setting yourself up for another 6 months of litigation because there's going to be a claim that the money that you earned was community. The title companies are usually going to require, it's almost always going to require that the other spouse sign off on that quitclaim deed, by the way. So it's not something that can be done unilaterally. So, property can be purchased post-separation, but there should be some considerations. The other thing is when you buy a house, and I know because you're a realtor, you know this,
Yes.
you normally have to fill out applications about what your income is, right?
Well, that's if you're applying for a mortgage. And
Sure.
Yeah.
Most people are going to have a mortgage, right? And they're going to have to declare what they earn.
Yes.
And some people might even puff a little bit in order to get that loan.
Yeah.
Guess what? How that plays out in family court. That means you get more money to pay support, right? Or maybe you were lying about your support over there and you're putting it on the application. So it's another consideration to take. The other thing is of course, when you're buying a house, that means that you have more assets available to you, and the court's going to look at that and say, well, you're not exactly poor, so we're going to factor that into the issue of spousal support. So there's tactical reasons to whether you're going to do it or not. In most cases, I tell people, why don't you wait? We'll get the divorce done and then you buy that house.
Yeah.
And by the way, I know somebody that could get it for you.
For more conversations like this and deeper insight around divorce, you can find us on our YouTube channel at Talkin Divorce. And until next time, bye.